defendant's motion to amend judgment of divorce. Will both parties please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Thank you. Mr. Velasco, apparently we got incorrect information regarding the offer. Is that correct?
Correct, Your Honor.
And the vehicle is actually in both of your names.
Correct, Your Honor.
The vehicle is awarded to the plaintiff, though, correct?
Correct.
And you are wishing to have your name removed. Is that
Yes,
correct?
yeah.
Now, but there's a note on this vehicle as well, correct? A loan?
Mhm.
And your name is on it as well?
Yes.
Okay. How much money is owing on that note yet?
There's still 8,000.
Running $8,000?
Yes.
Okay, thank you. And I'm assuming you have no interest in the vehicle, but you just want your name off in the financial obligation as well.
Correct, Your Honor.
Okay, thank you. How much time is left on this now? How many more months of payments?
5 or 6
Is it 5 or 6 months?
for the car payment, right?
Yes.
Yeah.
If you're talking $8,000, that's a
Oh.
big payment. What's the monthly payment?
Monthly payment is 600 every month.
Okay. Probably have many more payments, just 5 or 6. Ms. Velasco, you still have the vehicle, correct?
Yes, I spoke to the car company and they were supposed to send me letters in the mail and they have not yet, stating that he called, asked to be put on the title.
To be put on the title?
Mhm. And it is, what they told me was the car payment still at $20,800 is what,
Still owing on the
that's what's
vehicle?
still owing, yes, and it's $606.95.
Okay. Did you contact the finance company to refinance the note to have Mr. Velasco's name taken off?
But the dealership is going, I have an appointment set up the first week of January to upgrade my vehicle to have them removed completely.
And you intend to do that by next month?
Yes. They were just waiting on more options for me to pick from for a new vehicle.
Oh, you're going to trade this?
Yes.
in? Oh, I see. Okay.
And then they're just going to take the payments that I still owe on it and add it to the new car.
But they're going to remove Mr. Velasco's
Yes,
name?
yes.
Okay. Mr. Velasco, what are your thoughts of, I'm going to order that Ms. Velasco refinance this within 90 days to remove your name. If there's a problem with that, you can come back before the court and motion it up and we can address it if it's not done within 90 days.
Okay.
Any objection to that?
Nope.
Is any objection to that?
Nope, like I said, I'm going to the dealership, so.
Okay.
And one thing, Your Honor, I did not call Capital Chrysler like Ms. Williams has said. I have not got in contact with them at all.
It doesn't matter. Here's the deal though. The motor vehicle was awarded to plaintiff in this matter. The court was under the impression that it was only in Ms. Velasco's name. It's not. As a result, the court will order that within 90 days from today's date, Ms. Velasco is to refinance the vehicle, whether it be a trade-in or whatever it might be, to remove the defendant's name from the note. I will also order that the defendant is held harmless and the plaintiff shall indemnify the defendant therefrom from any further obligation regarding the note. What that means, essentially, that Mr. Velasco, it's not your responsibility to pay the debt. She has the vehicle, she pays the debt. However, I can't stop the bank from coming after you in the event she defaults until it's refinanced.
I understand.
Because I can't invalidate the contract. But Ms. Velasco informs me that she'll be able to do this within 90 days. That should take care of the matter. Go ahead.
And also, I had to speak with a police officer yesterday, Mr. Velasco. I was informed that our restraining order, that he can still contact me. He has been contacting me. He threatened me last night that he was going to kill me. And I have the text message to prove it.
Okay. What restraining order?
The PPO.
Did you contact police?
Yes, and they told me to bring it up in court this morning, because
Which police agency was involved?
Huron County.
Who's the deputy?
It was a female. I can't remember her name, but I spoke with her last night.
Because, again, it's not before the court. If there's an alleged PPO violation and law enforcement is called and there's probable cause to believe that the PPO was violated, that individual is placed under arrest.
Yeah,
Immediately.
they said because they're on the PPO that it states that he could still contact me, that he just can't come on my properties.
Okay, I don't have the file in front of me. You'll have to file a motion. We can.
Okay, all right.
Okay, that's how we'll leave it. 90 days to get this
Yep.
done. If it doesn't happen within the 90 days, sir, after the 90th day is up, you can file a motion, again, address it. Good luck to both of you. Thank you. Off the record. This is the plaintiff's motion regarding support. That is Mr. Gola. He is in the courtroom. Court calls Lindsay Hartman. Lindsay Hartman, no response. This matter is scheduled for 9 a.m. It is 9:26 according to the clock in the courtroom. There's a certificate of mailing from Alicia Thomas, family court clerk, dated November 20th, 2024, serving Ms. Hartman with this motion regarding support. So there is proper service the court finds at this time. However, the defendant is not present. Mr. Gola, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Mr. Gola, you're currently paying support, correct? And you are alleging in your motion that the child has been with you
Yeah, he moved back home about 2.5 months ago.
2.5 months ago. And how often does Ms. Hartman see the child?
No, she don't.
Not at all?
They text back and forth, but they just argue and constantly argue. And
So you believe there's a change in circumstance here because of the fact that the child has moved back or moved in with you? Anything from the front of the court on this?
No, Your Honor, although I would ask the court to consider if the child is residing with Mr. Gola, doing an abatement of the current obligation.
I'll order that. And number two, we'd have to have a front of the court investigation regarding support. Correct, Ms. Schultz?
Yes.
Order that as well. The support is abated, stopped at this point. And Mr. Gola, provide your income. There'll be forms you have to fill out regarding your income information.
okay,
That has to be provided to the front of the court. They're going to recalculate the report based upon you having the child.
okay.
Once that report is completed, you'll get a copy of the report. Either party can object to it. Ms. Schultz?
And just to confirm for the record, Your Honor, the effective date for both abatement and the review and modification process will be November 20th. 2024.
Yes. Date the motion. Yep. Thank you. We're all set, Mr. Gola.
Thank you.
You're welcome. Have a good week. There's a motion regarding custody. Plaintiff is present in the courtroom. The defendant, Mr. St. John, appears via the Zoom application. Will both parties please raise their right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You may put your hands down. Ms. Camacho has filed a motion regarding custody in this matter. The court takes judicial notice of another file. We won't mention any child or children's names here. Court takes judicial notice of an NA file. Ms. Schultz, anything to fill in here?
I would just note that an order was entered on October 1st of this year, confirming that Ms. Camacho's parenting time is to follow the companion
Ms. Camacho, I read your motion. However, the companion case, which I'm not going to delve into for obvious reasons, has your parenting time currently suspended.
Correct.
So what is the court supposed to do when that file trumps this one?
Well, it was more, I filed an also a parenting time complaint with my motion. Basically, I should have, able to have concern for my child as a mother. Am I right or am I wrong? I mean, I feel like.
So if you have something to bring to the court, you bring it to the court.
Right. So one of the complaints was not driving with Peyton on
You're
an.
using the child's name when I asked you not.
I'm sorry, I didn't mean to.
ahead.
Driving with my daughter on a suspended license. That was recognized a couple of times. Him being,
Has this been reported to the people involved in the other file?
I have reported it, yes.
And what have they done?
Well, I'm not sure.
Okay.
I mean, there is another case open for allegations against Mr. St. John since then. Since October.
I'm not aware of that one. I'm aware of the one.
Current, yes, I understand. Yeah.
Okay.
So like they're still investigating that, according to my knowledge.
Okay. Anything else?
Well, just kind of the stuff that she needs to be in that were per friend of the court order that was established in 2022 and it not being addressed properly per CPS and per Mr. St. John. And that's one of the main concerns is that her mental health is being addressed.
Sure. Mr. St. John, any response to this, sir?
Yeah, Andrea's been isolated from everything. We've already talked about, I'm not supposed to drive her and all that. I've been obeying the orders, every order I can obey. I obey. Of course, me and Peyton have our issues here and there.
Hey, you use the child's name as well. Please don't use it.
Yes, sir. I'm sorry.
Well, let me ask you this. Is the child getting the mental health treatment?
She is getting it at school. But as for there's nothing in our area. We've tried our local therapist and we didn't like that. Anything close is either in Gaylord, which it was a conflict with volleyball and all this stuff, but she has been in volleyball and she's in a church group.
Volleyball is more important than mental health treatment?
I mean, you might not think so, but this volleyball has been more beneficial.
Oh, I think so.
Yeah.
Mental health treatment in volleyball. I mean, I don't think there's any issue there, sir.
No, that's not what I'm saying.
Well, then what are you saying?
The school's supposed to have a therapist, and I call every couple weeks and check on this situation, and they cannot source a therapist for this school. And so now we got the elementary lady visiting her, but it's still not a perfect situation. It's not a weekly scheduled thing right now because the school doesn't offer it.
So when is the next hearing scheduled for review on the other file? Do you know? January 13th?
Yes, sir.
Okay. Well, obviously nothing much is going to change from now until January 13th.
Correct.
The court is going to reserve this issue. I put it this way. The court at this point has to deny the request because the NA case controls here. However, it will be addressed on January 13th. So, Mr. St. John, if there's any concern regarding orders that need to be followed, we'll be addressing it on that day. So I would be following through. And for the record, no disrespect, but mental health is a heck of a lot more important than volleyball. Do we have an understanding?
I do. Yes.
Okay. Motion is respectfully denied because the other file trumps this one relative to custody and or parenting time. However, will be addressed on the review in January. That'll be a defendant's motion to change domicile as well as requesting other relief. The defendant is present in the courtroom, represented by attorney Julian M. Ferris. Sorry, what is your name?
Helen. Karen.
Okay. Ms. Heron, you can have a seat right over there, please.
Where's your attorney?
Oh, she's not here.
Yeah, she's not here. I didn't know if I had to come or not. Oh, I didn't have to. Oh.
And since then, the plaintiff has joined us. She is in the courtroom, represented by attorney Dawn Young. Ms. Young is not here. Ms. Ferris represents Mr. Hanson. Will both parties please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. Ms. Ferris had contacted the court this morning and advised the court that apparently there was some sort of settlement reached between the parties. And the court was further advised that as a result of that, Ms. Young would not be appearing, and the court kind of implied that Ms. Herron would not be here as well. But Ms. Ferris, is that a fair assessment of our conversation?
Yes, Your Honor.
And there is an agreement, correct?
Yes, the parties had an opportunity to meet with Ms. Schultz and the friend of the court and have reached an agreement, which I would ask Ms. Schultz to put on the record. I will prepare an order for that and submit it to the court. And the agreement that will be permanent addresses one child only. We would ask that you preserve the issue with regard to the other child, and that will be renoticed if necessary prior to the next school date. Yes, we're engaging in a temporary agreement that will go through the second semester and have agreed to reconvene with the friend of the court after the second semester.
So this is not DJR, this is DLH.
DLH.
DLH is
DLH is
permanent.
permanent?
No.
No,
DL,
DLR is permanent.
DLR will be permanent, and Ms. Schultz will put that agreement on the record, and I will prepare an order.
DJR,
DJR.
Permanent destiny
That's what I thought.
Oh,
abeyance.
sorry.
Or,
In the-
or-
yeah,
Permanent
sorry.
DLH,
Sorry.
not. Wish to have Ms. Schultz place this on the record?
the agreement that we reached with the friend of the court, yeah.
Okay, go ahead, please.
As to the minor child DJR, the parties will be granted joint legal and joint physical custody, with Mr. Hansen having primary physical domicile of the minor child. In addition, parenting time will be granted to Ms. Herron, be exercised from Friday at 8 p.m. until Sunday at 2 p.m. on the 4th and 5th weekends of each month. Mr. Hansen will exercise parenting time with DLH on the off weekends. And I know Ms. Ferris had indicated that DLH was being preserved. The parties are still working on that issue. The parties had indicated at ADR, previously Mr. Hansen was providing all of the transportation for the minor children. And they are, I believe they intend to modify that provision so that it is shared with the parent exercising parenting time being responsible of the children. And I believe that was the entire order. Support had previously done it last based on the shared custody of the children.
Ms. Ferris, do you wish to inquire of each party relative to the proposed agreement?
Can we do both at the same time?
You can, sure. They're both under oath.
Did you hear the agreement that Ms. Schultz put on the record?
Yes.
Was that your understanding of the agreement that you reached as to Dakota and ADR?
Yes.
And would you like the judge to order that and make that permanent?
Yes.
And with regard to the other child, DLH, we have reached an agreement as to her temporarily, correct?
Yes.
And we are preserving the permanent determination of that for another time, and we will renotice this hearing later. Correct?
Thank you, Ms. Ferris.
And do you feel that this is in the best interest of your children at this time?
Yes. All right, thank you. Ms. Herron, your attorney is not here today, so I just want to make sure for the record, no one has twisted your arm. This is an arm's length agreement where both of you agree on this, and it's in the best interest of the children, correct?
Yes.
Because your attorney's not here. I just want to make sure that it doesn't come back later. Someone doesn't come back later and says, you know what? I didn't have my attorney with me, and that's not my understanding. You understand what I'm saying?
Yes,
And this is your understanding as placed on the record by Ms. Schultz.
yes.
Thank you. The court will grant the relief as requested. Ms. Ferris will prepare the order. How much time do you need to prepare it, Ms. Ferris?
2 weeks, Your Honor.
Sorry?
Could I have 2 weeks, Your Honor?
Yes. Yes. We'll schedule a review for January 3rd. 2025, 9 a.m. If there's no order in the file, all parties and counsel need to appear. Otherwise, if the order's in the file, have a great holiday. Good luck, folks. 591 DM. This is the plaintiff's motion to enforce the judgment of divorce. Both parties are present. Mr. Geiger appears in pro se, means he represents himself. Ms. Keel is represented by attorney Julian M. Ferris. Will both parties please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Sorry, I didn't hear you.
Yes.
Thank you. Ms. Ferris, you may proceed.
Thank you, Your Honor. Julian Ferris on behalf of petitioner Vicky Keel. And we are here today on my client's motion to enforce the judgment of divorce. The judgment of divorce was entered into on March 3rd of 2008 and states that the plaintiff and defendant shall be equally responsible for the cost of 4 years of college and or trade school for their minor children. The parties have 2 minor children, DG and KG, and they're twins. And they both graduated from high school this past June and are now enrolled in college. DG attends Lakeland State in Illinois, and KG attends Ross Medical School in Saginaw. College and or trade school expenses at the very least include room and board and books and tuition, Your Honor. My client has mailed these bills to the defendant and all have been returned unopened. I mailed the defendant a letter on September 26th requesting payment of the enclosed expenses that I did put in my letter and asked that he pay back in 30 days. I received no response. I do plan on calling my client as a witness and presenting the court with evidence of the college expenses to date. And we are requesting that the defendant be ordered to pay half of these expenses pursuant to the judgment of divorce. And then we are asking that you hold them in contempt for failing to follow the order and for forcing us to file this motion. And we're asking for actual attorney fees for having to bring this motion to the court, Your Honor. Thank you.
Thank you. Mr. Geiger, do you wish to provide an opening statement at all, sir, or do you want to provide that a little bit later?
Probably a little later.
Okay. Ms. Ferris, you may call your witness.
Can I call Vicky Keel to stand, please?
Ms. Keel is already under oath. Just have a seat here, please.
And you're the petitioner and the plaintiff in this motion, correct?
Correct.
And this is your motion to enforce the judgment of divorce, all right?
Correct.
And was your judgment of divorce filed in this court on March 3rd of 2008?
Yes.
How many kids do you have?
2.
And how old are your children?
19.
And where do they attend school?
Dalton is at Lakeland in Illinois, and Krista, I'm sorry, I can't use her name. She is at Ross Medical School in Saginaw.
And pursuant to the judgment of divorce, Mr. Geiger was to pay half of the college or trade school expenses for the children for 4 years, correct?
Correct.
And has Mr. Geiger ever paid you half of the expenses pursuant to the judgment of divorce?
No.
I am showing you what has been marked, or this marked.
Just please show them to the defendant in this case so we could just move along. Ms. Ferris, what is proposed to you?
Proposed exhibit 1 are the housing expenses of the minor children. Proposed exhibit 2 is the tuition expenses. And proposed exhibit 3 is a returned unopened piece of mail that contains the bills that we sent to Mr. Geiger.
Any objection to their admission, sir?
Just, well, I don't know what,
Any objection to the court looking at that to consider?
as far as the rent, Krista, she hasn't even stayed there at all.
Well,
one night.
We'll get
Okay, all right,
into those issues,
all right.
but any objection to, at least to these exhibits?
No, except for that, the mail, I never signed for that. And I never got it.
Okay. Be noted, all 3 exhibits are admitted.
Showing you what has been marked as plaintiff's proposed exhibit 1. Do you recognize this document?
Yes, I do.
And what is that document?
That is Dalton's apartment expenses.
And the exhibit has already been admitted. Is it just Dalton's expenses?
No, it's all it's all expenses for both children.
And both children have apartments or a dorm where they're,
Apartments.
is dorm or school housing an option?
No.
So they have to have an apartment at their school?
Mhm.
And
Yes.
do you pay Dalton's rental expenses monthly?
Yes.
What about Krista's?
Krista's was paid in a 6-month one-time payment. We saved money by paying a one-time payment.
And approximately how much per month would her rent be if you spread that out over?
Roughly $900.
How much?
$900.
So her rent is $900 a month?
Yes.
How much is Dalton's rent per month?
$612 per month.
$600. I'm showing you now what has been marked as plaintiff's proposed exhibit 2. Do you recognize these documents?
Yes, I do.
And what are they?
That is Krista's tuition bill.
Is Dalton's tuition bill in there?
No.
Why not?
Dalton and I wrote a scholarship, and he now is granted in-state tuition instead of out-of-state tuition, and he does not have to pay tuition at this point in time.
Excellent. So we're just looking at Krista's tuition then, correct?
Correct.
You have any forms you can fill out for me, for my children?
There's a lot.
Wow.
Yeah, we were happy.
So it's just Krista's tuition, and what is you pay? What do you pay per month for her tuition?
$500 a month.
And have you paid all of these expenses to date?
Yes, I have another one that comes out on the 19th.
And have you provided these receipts to Mr. Geiger?
Yes,
And how did you provide them to him?
in the envelope that I mailed to him.
And what was his response?
He said it came back to me in the mail. One of them did. The second one that I mailed, I did not receive back.
I'm showing you it's been marked as plaintiff's proposed exhibit 3. Do you recognize this?
Yes,
And what is that?
that is the refused mail.
Is that the actual letter that you mailed to Mr. Geiger?
Yes, it is.
And you did receive that back to you?
Yes, I did.
And what is written on it?
Refused 9/24/24, and it says return to sender, refused, unable to forward, return to sender.
Okay, so it clearly says refused on there.
Correct.
So what was contained inside of that letter, or both letters that you mailed him?
The bills for August and September were in this letter, and October was in the other letter.
When did you mail the one for October?
The first week of October, because I received Dalton's, he has to pay his rent by the 5th, and as soon as he paid it, I sent the bills out.
But you haven't gotten the second one back yet?
I have not.
Other than your letters and my letter, have you done anything else to notify the defendant of his financial obligation?
I have sent a text message and asked him to pay half of Krista's $500 payment, and I get no response.
Does either child have any expenses for books or anything else with school?
I personally paid those.
Would you like reimbursement for the expense for books?
I'm fine. Thank you, though.
So you're just looking for the tuition and the housing expenses?
Correct, yes.
And what is Krista's monthly housing expense?
It's $900.
Did she have rental insurance?
Yes, she did.
Was that a one-time payment for the year?
Yes, it was.
And how much was that?
$193.
So that's roughly $16 per month if it was divided out over the year, correct?
Correct.
And you said her tuition expenses were what?
$16,297.
And you're paying that in increments of,
The school and I agreed on $500.
so you pay $500 per month to pay that off.
Yes,
So would you say these expenses are incurred year round? Are they spread out over the year? Or is it just during the school year?
no, they're going to be paid until they're paid off. So it could be 2 to 3 years before I get that paid off.
Will she get another tuition bill next year?
No, she goes to a trade school and that is her program amount. She gets a program amount. For her whole program, it's that a set amount. There's no new tuition after the semester.
Okay. And I heard Mr. Geiger blurt out that she doesn't even live there, so why should I pay for it? Can you explain?
Yeah, Krista has an apartment in Saginaw. We went ahead and she was having some problems mentally staying there by herself. And we had already paid for the 6 months and we are keeping it at this time. In case we have snow or weather or that she can't get home, driving from Saginaw to FedEx has been a little challenge for her. And so we are obligated to keep it for 6 months.
Does she stay there on occasion?
She can stay there, yes. She has lived
Is there
there.
a reason why she's back here?
She has a job back here.
Okay, so she's working and going to school?
Yes, she is.
Okay. And is there any other expenses that you think that Mr. Geiger should be responsible for pursuant to your judgment of divorce?
No.
The rental insurance for Krista, you said was approximately $16 a month, correct?
Correct.
Rental payment for her was approximately $900 a month.
Yes.
The tuition payment is $500 a month.
Yes.
And then Dalton's rental payment is $612 a month, you said.
Yes.
And this comes to a little over $2,000 a month that you're paying.
Yes.
And what are you asking the defendant to pay?
I would think $1,000 per month
Half of those expenses.
would be half of those expenses. Those are expenses that I incur every single month.
And you have already paid for, when did school start?
August.
Did you pay for August, September, October, November, and December?
Yes.
So 5 months at approximately $2,000 a month. He would owe you $5,000 from August through December, correct?
Correct.
And then you're looking for beginning January 1st, $1,000 going forward for 4 years until they graduate?
Yes, both of my kids will graduate before the 4 years.
Okay, so it's not even.
It's not even 4 years.
Okay. And that you said that $500 payment for Krista, that's it. When that's paid off, it's done, right?
Exactly.
Is there a chance that Dalton will incur tuition expenses in the future?
Yes.
And why is that?
We have to apply for the grant or the scholarship on a semester basis, which this next semester's has already been taken care of, but we don't know any further than that.
If he happens to get a tuition expense in the future, do you expect Mr. Geiger to pay half of that?
Yes.
I have no other questions, Your Honor.
Thank you. Geiger, do you have any questions of the witness?
As I don't know, I guess I don't have no questions, but
Okay. If you don't have any questions, I don't. You may step down. Further proofs, Ms. Ferris?
Do I?
You can leave them right there. Thank you.
No, Your Honor, I have no further proofs.
All right. Mr. Geiger, do you wish to provide any testimony or any comment regarding this motion, sir?
as far as from what Dalton told me with his,
We can't go into what Dalton said. That's hearsay.
okay.
What's your,
As far as proof that she actually paid for his dorm. Or for his apartment.
I don't understand. What are you saying?
I was under the impression that Dalton was paying for his own apartment out of his own pocket. From one of his CDs.
Okay. Anything else?
And as far as the her for summer Krista stay in Saginaw when she's down there. I had 3 relatives that offered her a place to stay down there. And she's been there, from what I was understood, she stayed there one night, and it's kind of a waste of money. If she only stayed there one night.
Anything else, sir?
Honestly, there's no way I can afford this. I can't even get a loan at the bank. If they garnish my check, I'm gonna lose other stuff, my house. I ain't gonna be able to make payments on anything else.
Okay.
And I've told Vicky that more than once. And Dalton understands that too.
Well, we can't go into what the children understand. It's an order, a judgment that was entered in this case. You understand you agreed to pay pay the college expenses for 4 years.
I was 17, 18 years, and I thought I'd be more financially ahead by now, but I'm not because of what happened in the divorce.
Final argument, Ms. Ferris.
Thank you, Your Honor. The judgment of divorce clearly says that they're to split the cost of college for their children for 4 years. And to date, the defendant has failed, neglected, or just flat out refused to pay anything towards his kids' college expenses. The total expenses today comes to a little over $10,000, half of which is approximately $5,000, which is what we are asking for today in reimbursement since the beginning of the school year. And as testified to, going forward, beginning January 1st, we are requesting that the defendant pay directly to the plaintiff $1,000 a month for the rental insurance, and the tuition expenses of his children. The plaintiff has voluntarily taken the expenses of all the books. She has applied for a scholarship for their son, so he is tuition free. She's doing everything that she can to ease the financial burden, and she's going into debt now because she's doing this all on her own. And these kids have a dad. He should step up and help them pay as promised in the judgment of divorce. And in addition to that, because we had to bring this motion to enforce today, I am requesting actual attorney fees be paid in the amount of $600 by the defendant for this motion. Thank you, Your Honor.
You're welcome. The total you're asking, though, on behalf of your client is $5,000, correct?
That would be half of the expenses to date.
Date.
And we're requesting that he pay $1,000 per month going forward, because that is the expense for this school year.
Geiger, any final argument, sir?
I don't know what to say. There's no way I can afford that $1,000 a month. No way. You're probably gonna see me back in court for other stuff that I can't pay for is what it comes down to.
On March 3rd of 2008, a judgment of divorce was entered in this case. The judgment of divorce indicates on page 9, the second to the last paragraph. It is hereby further ordered and adjudged that plaintiff Vicky L. Geiger and defendant Keith J. Geiger, I'm just reading from the date from the original judgment, shall be equally responsible for the cost of 4 years of college and/or trade school for the minor children. Testimony presented during the hearing indicates that both children are enrolled in school and/or vocational training. Son, I believe, was at Lakeville? Lakeland. And daughter is at Ross. The plaintiff has provided the court with the expenses to date, including the 3 exhibits that have been entered. This issue of the one of the children not residing in the apartment, testimonies was presented that the lease was entered into and they paid up front for 6 months, which saved a good amount of money. For whatever reason, the child had issues there, but that's still an expense that was incurred. The fact that she may not have been there has no bearing upon the court's decision today. I give mom credit for seeking relief that is in the form of tuition grants or scholarships, whatever she may be doing with this Lakeland school, which significantly drops down the amount of money owing. But this court finds that the judgment is very clear. It's very clear that it includes 4 years of college and or trade school. Now, one could argue, well, wait a second, it doesn't say room and board. Well, if you go to another school, another location, to me, it's just common sense that includes room and board, and it does. If you're going to a school outside the confines of a normal drive, certainly there'd have to be some sort of housing arrangement, which the court finds is encompassed within the judgment. As a result, the court is going to order that father renewing it is responsible for half of cost involved here. Court is going to order the $5,000, and the court is going to order $1,000 per month moving forward. Father says he doesn't have the money. However, the dialogue door has to be opened, and it's going to have to be addressed some way, somehow. So the parties need to communicate with each other. But I'm ordering the relief requested by the plaintiff. Also, as to attorney fees in this matter, the court finds that the plaintiff had to seek counsel to enforce the judgment in this matter. As a result, father is also responsible for the $600 in attorney fees. How much time do you need to prepare the order?
2 weeks, Your Honor.
All right, January 3, I believe is what I said.
Yeah.
January 3rd, 2025 for review in the event the order is not on the record. In the record, I should say. That'll be all. Thank you.
Thank you, Your Honor.
3DS. This is show cause and alleging contempt on behalf of Mr. Page. Mr. Page appears via the Zoom application. Ms. Oswald is in the courtroom. Will both parties please raise their right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Before we delve into this, again, please don't mention the child's name. As I understand it, Ms. Oswald is claiming that father denied her the parenting time for the child's birthday.
Supposed to get her from 9 a.m. to 9 p.m. this year.
Denied giving my daughter to me on Saturday, November 16th, 2024 for her birthday from 9 a.m. to 9 p.m. Denied phone calls, ignored my calls, refused to even open messages and app close until the next day. And you state there was no verbal agreement of him keeping her.
I had no verbal agreements. I had no agreements in the app, on Facebook, Snapchat, or Facebook Messenger.
Okay, so your understanding then, according to the current parenting time order, was that you were supposed to have the child on the 16th for those 8 hours?
Yes, sir.
12 hours, actually.
Yes.
Ms. Schultz, is that the understanding of the front of the court regarding the order?
Yes, Your Honor.
Oh. Mr. Page?
Yes, sir.
How do you respond to this, sir?
I responded this by stating that I was only doing pretty much what was done for the order because the previous year beforehand, I did not get to see my daughter for her birthday per Mrs. Oswald because she had me on the do not release list for my daughter's school. I was supposed to be able to pick my daughter up from school to celebrate her birthday with her, and because Ms. Oswald had me on the do not release list, I was not able to see my daughter for her birthday.
That was last year, correct?
Yes, sir.
Okay, so where's the court order saying that you have the child on Saturday, November 16th from 9 a.m. to 9 p.m.?
There was a verbal agreement between me and Mrs. Oswald that because I wasn't able to see my daughter on her birthday last year, I could have her this year.
Okay, so you're claiming a verbal agreement between the two of you?
Yes, sir. There was a verbal agreement on Facebook Messenger, but because she tried to use my Facebook against me, I blocked her from my Facebook because she took me to court over a Facebook post previously before.
Okay, so the Facebook Messenger, are you talking about use of the Facebook phone feature, or is this texting back and forth?
Like a messenger, like the Facebook Messenger, like that goes with Facebook.
Okay, so it's not a verbal agreement then. It sounds like a written agreement.
Yes.
Do you have that with you?
It was also discussed over the phone between me and Ms. Oswald.
Okay, well, she denies that, but do you have the Facebook Messenger post summarizing what you just stated?
I do not, because I blocked her off of my Facebook because she also tried to use a post of my Facebook by constantly looking on my page and trying to use my social media against me, involved
Okay,
in
but
this
if
case
she,
dealing with my daughter.
if you blocked her though, you should still be able to grab that message, wouldn't you not?
No, sir.
Still
Once
have-
you block someone on Facebook, it deletes everything that you have in contact with them.
Okay. Okay, well,
I'll gladly hand my phone to you, sir.
well, you don't need to, because frankly, a verbal agreement is not worth the paper it's written on. And I mean no disrespect by that, but we need to have something in writing to indicate that. There's nothing in the record to indicate that there was some sort of written agreement. I'm not taking one word over the other, but verbal agreements, again, they don't hold water with the court unless there's more to it. Recording, something, someone else heard the conversation, nothing. As a result, I find the defendant in contempt for failing to provide the child to mother for her scheduled time. Mr. Page, two wrongs don't make a right, but is there anything you'd like to say before the court imposes disposition?
If that's the case, Your Honor, why should she be able to get her 2 years in a row if she prevented me from being able to see my daughter last year? That's not fair to me at all. That doesn't sound like 50-50 custody in my eyes, if that's the case, Your Honor.
Well, I don't disagree with that, but court orders are court orders. Those have to be enforced.
She was also invited to the party, but because she doesn't want to communicate with me at all, like as I've been extending multiple olive branches to Miss Oswald, trying to better our relationship for our daughter, that like it doesn't make sense to me. Like she's constantly making it difficult to communicate when I'm constantly extending olive branches trying to communicate about my child. She
Well,
wants to
let's
continue
talk
to make
about
it an issue about everything else other than talking about my daughter. Every time I try to communicate with Miss Oswald about my daughter, she manages to bring my girlfriend and her children into the conversation when that's not what we're talking about at all.
Okay, so let's talk about communication for a second. Attached to the motion is basically the history on app close, where it appears Ms. Oswald is trying to reach you and it's canceled. No response, no response. Messages sent, no response. The next day on the 17th, then you respond at 8:49 in the evening, which is nearly 24 hours from the time that mom was supposed to have the child. So it kind of cuts both ways.
I understand that, but as far as communication wise, me answering wouldn't cause anything but issues, because from the very start of that morning, she was messaging my mom, harassing my mom, messaging me continuously, knowing that our daughter was with me, knowing that my daughter has been talking about her birthday party since February. Miss Oswald has known this is supposed to happen since February. There was no denying then. There was no arguments about it then. And we've been to court multiple times since then. She's said nothing about it. She's like, that's the
Paige,
part
all
that
I
I
can
don't understand.
suggest to you is next time get it in writing so that there's no issue. I'd turn back to the front court. Has there been
the cops were there? Like she literally called the cops on me on my daughter's birthday, attempting to ruin my daughter's birthday, and the cop even said it didn't.
I had the Canton Police Department go for a wellness check on my daughter because of the factor of the inability to communicate back with me as to what was going on that day.
Okay, well, I'm moving forward with this. Ms. Schultz, have we held either party previously?
The court has found Mr. Page in contempt previously, but not as it relates to the parenting time schedule. It was related to communication.
Okay.
Excuse me, legal custody complaint for cutting these kids.
Okay. Who is the child next year for birthday?
It's supposed to be him.
May I suggest, Your Honor, because we do have, friend of the court policy is like for life when there's makeup parenting time awarded to a parent. So if it's a weekend, you get a weekend back. If it's a holiday, you get a holiday back. But we do have the Christmas break up coming in 2 weeks. I would ask the court to consider just having the child return the full day early.
How do you feel about that?
She starts the winter break with me, so she already is with me from when school lets out on that Friday until 10 a.m. on Christmas morning. So if that were the case, when would I have to give baby to him?
10 a.m. on Christmas morning. What I had said is, I believe what the court intends to do is award you one day of make-up holiday parenting time. And so Mr. Page has the second part of Christmas break, which is 10 a.m. Christmas Day until 6 o'clock the Sunday before school resumes. I don't know with the school schedule what day they go back, the 6th of January. So I would recommend that the court order that she be returned the morning of January 5th.
How do you feel about that?
I'd be okay with it, but then my question is who gets her next year for her birthday? Because he destroyed a bunch of plans that I had. I was gonna take her down to the circus, the Soul Circus down in Detroit.
Well, pursuant to the previous order, he would have birthday.
So I don't get her for her birthday
I would have no
for
problem
2
with
years
her
in a
getting her
row.
birthday for next year and just literally swapping the birthdays. That way it makes it even again for both of us. Why not just do that? That would be
Sounds like dad wants to give up birthday and give birthday to mom.
Next year, or
what I'm saying is like how she was able to have her last year and I had her this year. If she just gets her next year, that would make things even as far as birthdays. I don't understand why there has to be extra.
May I make a statement?
Let me hear
the
from Ms. Schultz.
proposal would be to switch so that Mr. Page has even numbered years and Ms. Oswald has odd numbered years for the birthday holiday. Correct.
Is that what you're saying, Mr. Page?
Yes, like with the fact that we've already had her once prior to previous birthday that just passed. She had her the one before. I had her this year. She can have her next year for her birthday. That's why I don't understand what the issue is and why we're even here. If Ms. Oswald would communicate with me about it, this could have been avoided completely.
Well, okay, but so you're offering next year for birthday. What about the year after that?
Then it comes back to me. Like I'm literally just saying we could switch years on the birthdays. That's all I was.
So
that's all I was.
Even an odd would swap.
Yeah,
May I make
that's
a
all I was
statement?
putting out there.
Sir?
Go ahead.
So last year, the reason why he didn't get her,
We don't need to worry about last year. Let's focus on moving forward. I've granted your motion. And I want to know from you, what are your thoughts about having birthday next year?
so that means she'd be returned to me in the morning on a Sunday.
I don't know when her birthday is.
It would fall on a Sunday next year.
Okay.
I'm already supposed to get her back at 6 p.m. Where is the equalization of timeframes? Because I had, like I said, I had a bunch of things planned and she knew about them
A bunch of things planned for when?
for her birthday this year.
Okay, well, I
called
can't,
here, so-
I can't turn back time. Do you want, what do you prefer? Do you wish to have the child for her birthday next year? Or do you wish to have one day added to the Christmas parenting time?
I'd rather have her for her birthday.
So you'd have her for next year?
Yes, sir.
Okay.
Your Honor, is that then a permanent change to the holiday schedule, birthday?
That's what I want to make sure of. So we would be then, you would have next year for birthday, he would have the year after that, continuing to alternate. Does that work for you?
I'm okay with that, Your Honor.
That's what the court will order. The court is also going to order a $100 fine. Mr. Page is to pay the fine by January 3rd, 2025.
No problem.
And the court. Okay. So that's how we'll proceed forward. Ms. Schultz will prepare the appropriate order. Again, I can't stress enough to both of you, we had the chance to meet this child a while ago, and I know she was excited about her birthday. And let's move forward, and parties need to communicate. That'll be all. Thank you. Off the record. Matthew Schultz. This is the defendant's motion regarding custody. There's also an objection to a friend of the court recommendation. Parties are present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you. There is a previous judgment in the file, July 26th of this year, granting the parties joint legal and joint physical custody. Ms. Schultz, is this your?
Yes, Your Honor.
Can you explain to the court what's going on here?
As the judgment of divorce that was entered did grant the parties joint legal and joint physical custody, and it also awarded parenting time pursuant to the mutual agreement of the parties. My recollection was that the parties had agreed to exercise equal parenting time with the minor children. The friend of the court was referred the issue of child support as public assistance benefits are being received on behalf of the minor children. We did complete that recommendation and recommended that Mr. Schultz pay child support in the amount of $293 per month, including $69 ordinary medical for 3 children. And that was retroactive to January 26, 2024, which was the date the complaint was filed in this cause of action. This is Mr. Schultz's objection. I'll let the court take further proofs as to why he disagrees.
Okay. Mr. Schultz, what's the objection to the support amount, sir?
I feel like I have them half of the time. I pay for their stuff at my house. I agreed to pay the $69 for the medical for that. I don't feel like I should have to pay the rest because I haven't had time. I pay for their food here, all their stuff that won't pay me at our house. I pay for dance. I have life insurance for them.
There's public assistance involved as well, correct?
And what's that?
Public assistance to help the family?
Their Medicaid, their insurance, their health insurance.
That's what I agree to pay. It's the 69 or whatever it was to pay for that.
Okay, but if there's public assistance, you're looking at the relative incomes, not relative, the incomes of parties, and then a calculation is done. Ms. Schultz, because there's public assistance involved, I'm guessing that's why, despite the fact that they may be week on, week off, based upon the incomes, there's support, right?
We ran the court calculation in accordance with the Commissioner's Test formula as required. I do see that in terms of assistance, it is medical only. The court does have discretion for deviations under the formula if there's an agreement with the parties, or if there's other grounds that are appropriate for deviation, but I haven't heard anything so far that would warrant one of the other acceptable deviations.
And what are the deviation factors you think may be pertinent here?
I haven't heard any that may apply here, but generally speaking, we would be looking at excessive medical costs for a parent or one of the children. There's 15 different
I'm sorry, I'm putting you on the spot.
That's okay. I can need one moment. The court may deviate when a child has special needs, extraordinary educational expenses, a parent is a minor, the resident's incomes are below the threshold to qualify for public assistance. There's a reduction in the income available to support a child due to extraordinary levels of joint that. The court awarded property in lieu of support. There's extraordinary medical expenses for the parent or the dependent. A parent receives bonus income in varying amounts or irregular intervals. It can apply based on a person other than a parent providing health care coverage, step-parent, a parent providing support for a step-child, a child having extraordinary income, payment of property such as taxes, mortgage installments, home insurance, etc.
All 18 factors there. Okay. All right. So, and I have to ask Mr. Schultz, what are one of the deviation factors you think the court needs to consider here if you're seeking a deviation from the support amount of 293?
Like I said, I'm paying that. I pay that, and they have insurance that so that nobody takes loss.
Looking at the fact.
And I help give her money for things too before gas money, and give her money for school stuff.
Give it a response, miss?
Yes, Your Honor. The previous year, like since we separated, I did pay for her dance and her, both kids to go to camp. It was like $800. I don't have the receipts on me, but, my internet wasn't working at home, so I couldn't print stuff off.
What's your position on this motion?
My position is that I don't really care how much child support is awarded, as long as the kids still get their medical, because that's what's important. They need to be covered medically. That's what matters. However, I do have another motion, and you probably see it.
Motion for custody.
Yes. So that would.
What is the proper cause or change in circumstance warranting the court to review the custody?
I've listed them there, Your Honor. You can read them in front of you. I went through the factors. I went through everything online, and I just didn't label everything.
You're claiming that the children spend most of the time with you.
They do, because we do have 50-50 custody. I can honestly bring somebody to the stand if they're willing to testify. There are, I've been married into this family for 15 years, Your Honor.
Okay.
So there are family ties everywhere. And a lot of his family know that it doesn't matter who the kids are with. I don't want the kids not to have ties to grandma or aunts or uncles. A lot of my family have passed on. Okay.
But what is going on that you think custody should be
changed? I'm explaining. Okay. So since then,
I'm not hearing it yet. No disrespect.
I know.
What about this current CPS investigation?
Yeah, it's alleging that homeschooling is not being done routinely. And I would like to have them more often to make sure that it gets done more routinely. I know my mother.
Do you have any evidence to provide to the court regarding that?
Homeschooling is not done routinely?
Yes.
Just this open CPS investigation.
Okay.
And I would like to
Do you have a
close it.
CPS worker here?
No, he's not here. He's in Bay County. Because I live in Bay City, Your Honor.
We can have that person appear via Zoom.
Okay, yeah, because there's a little disconnect. There's behavior issues since the separation.
What is the status of that investigation? When did it start?
It started, I want to say maybe a month ago or so.
And there's no report or nothing back at all?
Well, he's getting close to, he thinks he wants to close it, but he did want to do a home visit. But I understand that my ex-husband refused home visit and visited them on site in Huron County with CPS here. So I don't know what's going on. I just know that I don't want to lose my kids, and they do need school. And my mother-in-law will testify that they do need school. She says that all the time.
Well, there's no question.
Yeah.
Children are.
And we've homeschooled for years. And when we lived in Harbor Beach and were married, we homeschooled really well. And then when I get back on track, yeah, it takes a while. Divorce things, behavior issues. My youngest still has behavior issues, but I still get reports that he does better at our house or my mother-in-law's house or any family member's house. But whenever I get the most calls and complaints from my children.
Do you have those reports with you? Someone to testify to them?
I have my mother-in-law in the courtroom right now. I'm sure she's here, not for me.
Are these reports prepared by whom?
No, I mean, like, she can testify as, she's the one that has the kids most often when they're at my husband's house. I 100% guarantee, and I know this because I have a location on my kids' devices, that when my kids are at my ex-husband's home for his week, she and her husband have them the majority of the time. Swear to God, Your Honor.
Okay.
And she can testify to that, and he can testify to that. They are both in this courtroom.
Okay, but what a parent does on their week is their business, but if it affects the child, the court can look at that. But
Exactly. So they do well there. They do well at my home. So when I'm getting phone calls and complaints from my children, it's not. It's when they're at mom and dad, or it's when they're in the Elkton home. And it's because he works a lot of hours, and the person he lives with is more hands-off with parenting.
Okay.
So there's a disconnect there, and they need school. They need to be schooled. And they are happier. You can just see it and feel it and know it.
Mr. Schultz, how do you respond to the allegation that the children are not following through with homeschooling when they're with you?
Yeah, they're doing fine. They seem happy with me when they're there.
Well, I'm not talking about whether they're happy or not. My question is, are they getting an education when they're at your house?
Some.
What do you mean some?
When I'm at work, I can't, do it, and, that my mom does help here and there.
Your mom or her mom?
My mom.
Your mom. Okay.
Who is at the courtroom? My mother-in-law, who keeps the kids the majority of the time.
When I'm at work.
But it's not her job to homeschool our.
Okay, we don't need to be going back and forth. I was asking
Okay.
of Mr. Schultz. You check on the grades? Sure.
That what?
Their grades?
It's homeschooling, so we do, like paper. I prefer really if they go back to regular school.
Well, that's not before the court, but because we have someone living in Bay County and you live here in Huron, correct?
Correct.
So how are they going to go to a real, I shouldn't say real school.
Traditional.
Brick and mortar school if one lives in Bay County, one lives in Huron? I don't either.
Exactly.
And I'm willing to do more if I can. First,
All right. Well, this is a motion for change of custody. There must be either a proper cause or change in circumstance. The court has to look to the prior order and then change the circumstance moving forward if there's a change in circumstance which would substantially affect the best interest of the child, materially affect the child. Again, from 7/26 to 24, the ink is still kind of not even dry yet on this judgment. Parties have joint legal and joint physical custody of the minor children. And both children, there are two children? Three children are homeschooled. Mother is alleging that the homeschooling is not really being followed by dad. It's really done by his own mother, the paternal grandmother. Court doesn't need to hear any testimony for that because but Mr. Schultz acknowledges that he does work and that time is devoted, so to speak, with grandma providing the assistance. I certainly don't want to fault anyone for working, but there's also the homeschooling aspect where these children need to get an education. And I also have to consider the evidence that's before the court. I cannot consider hearsay. I can hear vermins or allegations, but there has to be something that the court can hang its hat on. There's no CPS worker here. There's no documentation. I fully believe, Mother, that paternal grandmother would state that she's providing the education through the homeschooling. I don't find a change in circumstance in this case. So respectfully, the motion regarding custody is respectfully denied. But Mr. Schultz, if these children are not getting followed through with the education when they're with you, you come back before the court again, this could be a different story. Understand?
Yes.
Number two, regarding support in this matter, the court has heard nothing that would under the 18 factors the court can consider regarding deviation in this matter. Support is $293 per month, of which $69 is ordinary medical, effective January 6, 2024. The objection is respectfully denied. That'll be all. Thank you. 949 DM. This is Mr. Murray's motion regarding custody exchange. Mr. Murray is not here. He is not checked in via Zoom this morning. Ms. Murray was in the courtroom previously. I've been advised that she checked in with a friend of the court office as well. The court actually saw her enter the courtroom. The minor child, which we won't mention the child's name, has a doctor appointment, a significant one, and I'm assuming, Ms. Murray, that's where you're heading right now?
Yes,
And you're driving?
yes.
Okay. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
You may put your hand down, Ms. Murray. Don't look at the screen. Look at your driving, please. Just a couple of housekeeping matters, Ms. Murray. The court's been advised that you were at the front of the court's window, and there were some concerns regarding your monetary obligation. You paid half today?
Yes, I did.
When's the second half going to be paid?
The 26th.
I'll grant you till December 26th, correct?
Correct.
I'll grant you the time till December 26th to pay the monetary obligation. But just a word to the wise, I know these appointments get scheduled much in advance. If you know that you're going to appear via Zoom, contact the court earlier, let us know, because we can make accommodations for that. Number two is one child, not the one that you're addressing right now, but another child is supposed to be heading back or heading to Texas, correct?
Correct.
And according to what I read, Mr. Murray says he's not able at this time to take the child. Is that your understanding?
Yes, they are working on getting a 3-bedroom apartment, and the apartment complex denied them until February 1st. Instead of trying to do it in the middle of school year or in between the marking periods or semesters, he was just thinking if we could do it when I have to exchange the other one for parenting time during the summer.
At the end of the school year?
Correct.
Okay. Well, Mr. Murray's not here. He should be here. There's no reason he shouldn't be. He could have appeared via Zoom. But Ms. Murray, you stated on the record you have no objection to this, correct?
Correct. I have no objection to that, no.
Does the order indicate that the child's supposed to be switching the semester?
The order reads as close to the Christmas break as possible.
Okay, well, that's not going to happen. Court will order that order be modified to reflect the end of the school year. It's current school. Anything else, Ms. Murray?
Will that stop the child support?
We do have to address that, Your Honor.
Go ahead.
The friend of the court had issued a tiered child support recommendation, and neither party filed objection. So the order is ready for the court's submission to the court. However, because this motion was filed, I did not yet enter the support order. And so the friend of the court had recommended that Mr. Murray's support be set at $461 per month, including $36 ordinary medical effective July 9th. And then Ms. Murray's support was recommended to be set at $107 per month, including $40 ordinary medical effective December 1st. I would ask if the court wishes to modify the order to continue Mr. Murray's support obligation through May 31st of 2025, and then modify Ms. Murray's obligation as of June 1st of 2025.
Any objection to that, Ms. Murray?
No.
So ordered. So the support will change effective May 31. Okay. Anything else?
No, that's it.
Ms. Schultz, you got a couple?
No, Your Honor, thank you.
Okay, thank you. That'll be all.
All right, thank you.
Off the record.